Jose Ruiz, why do I keep getting this file back?
Oh, Lorraine actually had to run to the 186. I'll text her and let her know.
Okay. All right, we're done with that file. Kevin Corral.
Present.
All right. So today is discovery day on this case. Where are we on discovery?
I think we've received it, Your Honor.
Okay. And has an offer been tendered or no?
Just as we speak, earlier this morning.
Okay.
And so we haven't had a chance to confer with my client regarding the offer.
All right, Ms. Ferguson, can you recall this for 30 days for a plea deadline date? All right, we'll come back on November 30th. At that time, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, thank you. Once you sign the reset form, you're excused. Okay, but that one's done. Paris.
He's still downstairs, Your Honor.
They still have your client downstairs.
We're still waiting on a competency on this one, Judge.
Oh, you are?
I haven't received a report yet to see that they've completed their evaluation.
All right, let's do this. Let's make sure we get him out here so he can know what's going on, and then
Yes,
we'll get a date and everything.
Yes, ma'am.
Carlos De Leo. All righty. Where are we?
Trying to pick a side here.
Okay,
Morning.
good morning. Well, y'all have the brains of the operation behind you.
I know. She should
That's
be
what
up
I'm
front.
saying.
That's why I'm over here on the side.
Okay. All right, so where are we on this?
The last hearing we had, we got some results back from Houston Forensic Science Center, and we were requesting the underlying data to support those findings and conclusions. We've received that.
Okay,
I am in the process of giving that to my client and to our expert
Okay.
for analysis. Unfortunately, for my purposes, my client is not able to look at anything digitally, and it's a whole bunch of stuff digitally. And so
Okay.
I've got to put that all out, get it over to my client and to our experts. So they
he
can-
can't listen, he can't look at anything digitally? Okay,
There's no PDFs. Yeah.
all righty.
So that's where we are, and we're in the process of trying to get all that done. And I'm hoping that once we get that analysis looked at and done, we can get an expert opinion back on that and be able to proceed and go forward.
All right, how long are you all anticipating this? Because this is one where there is a conviction and we're just trying to see if that conviction is a
Right,
proper one.
right.
So,
Matt and I were talking today, and we're thinking at least 90 days, maybe even 120, get us through maybe February before we're gonna be able to have an expert review. It's a ton of stuff, Judge.
Okay.
It's just a ton of stuff. And so we've got to figure out, it just.
and your client is not in prison.
He is in prison. On this one, he's in prison. The other one, he's not. He's actually out on parole.
All right, so which prison is he located at?
He's-
So would it be easier to have him bench warranted back here? I know there's an issue with the time. Would that make things run smoother?
No, not really. I mean,
Okay.
because really what we're looking for is our expert analysis on the underlying data and the results that were obtained from.
Well, I mean, I know because you said he needed to review things. I'm wondering if that would make it easier. If not, then it won't.
Knowing my client, he wants it. He wants the actual results.
No, I mean, bring him here
Right.
and he can look at whatever you wanted him to look at. But if you all don't think that will make things run any quicker, that's fine.
It's not, Judge. I
All right.
appreciate that, though.
Sure. Ms. Ferguson, they're asking for 120 days. Normally that's never done, but okay.
It's just that we're not wasting the court's time coming back and
It is never a waste.
we're still working on it.
Okay.
And Judge, so the court's aware, the state is prepared to, I mean, the final piece of the puzzle here is that 6404 hearing.
Mhm.
We're prepared to move forward on that, but I mean, the big issue here is that Mr. De La has to carry his burden. We want to be able to, we want to give him as much time as possible, give Mr. McLean as much time as possible to review documentation here, basically be ready to have that final hearing. So really the last statutory requirement on the court is that 6404
Yes.
hearing.
And no, we'll have it. And I want to make sure that everybody has everything that they need to go forward. All right, we're going to come back on February 22nd, 2024. Time has gone by quickly.
All right, we will do our level best to be ready on that day, Judge.
All right, thank you. You're welcome.
See you then.
Nicholas Ramos. All right. So how many cases are we proceeding on? Just one, okay. All right, court is calling 2023 CR 3133B, State of Texas versus Nicholas Ray Ramos. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
You're on that side.
Anthony Cantrell for the defendant.
And are you Nicholas Ray Ramos?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged by indictment with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Okay, according to the plea, punishment is to be assessed at a cap of 16 years in the prison. There are no applications. This will run concurrent with County Court Cause number 6915448, 6915449, 694250. And there will be several cases taken in consideration. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Good.
State any evidence?
State offer states Exhibit 1 and all attachments. No objection.
All right, you may continue. First, showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. This will be set for sentencing on December 7th. We'll schedule PSI. And even though he's not applying for probation, I am going to schedule a TAP evaluation. That'll give me some idea.
Thank you.
Is there anything else, counsel?
No, Your Honor.
All right. We're going to come back on December 7th. I'll make a decision on your sentence based upon any other evidence that's presented to me in the TAP evaluation in the PSI. Do you understand?
Yes, ma'am.
All right, thank you. And the state tendered some dismissals, so I will give those to you.
Ready.
You're welcome. Just one moment. Let me have you all step back for just about 3 minutes because probation is in the box and this is a probation case. Oh, you ready? Oh, she's ready. Okay. Court is calling 2020 CR 0298, State of Texas versus Jesse Solis. Can I have parties announced for the record for the state?
Left hand for the state.
That
is for the defense.
And are you Jesse Solis? All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Jesse Solis Jr. who was placed on deferred adjudication in 2020 CR 0298 for the offense of assault family second offense on August 24th, 2021 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. On or about the third day of September 2021 in Bear County, Texas, the defendant Jesse Solis Jr. did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, the state would move to deny the MTR and modify.
Are you waiving the other allegations?
Your Honor, I appreciate it. Yes, we are waiving and abandoning the other conditions.
Any objections to the waivers?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, there is a proposed agreement for SADF.
Probation? Is that your recommendation? Because I have 2 questions. 1, is that your recommendation? And 2, has he done anything on probation?
Your Honor, the original recommendation was for Bear County ISF followed by ISP. However, speaking with defense counsel, she indicates that Mr. Solis may have a drug problem. Kind of looked over that, then we said SADF. My other thought was revocation. His last office visit with probation was February 18th of 2022. Your Honor, he has not completed anything on his probation. He did initially signed up for the Veterans Prevention Program, but we don't have anything on file that he actually completed it. And then he has not completed any of the other terms.
All right, has your client done anything on probation?
No, I don't believe he has, Your Honor, but I did have my visit with him. He informed me and I spoke to his mother as well. He had a stroke in 2008. And so he's got some memory problems that are nowhere in the court's records. He's had some auto accidents in 2011 and 2012 where he's got hit by a car. And the mom did confirm the memory problems. So I did have my visit with him, he knows he's on probation. He knows he was on probation. He absconded. I obviously asked him why, and he let me know that, that he does have a drug problem and he does want help. And he's asking the court to, he's not a convicted felon judge, that's why he's on deferred. So this is his first MTR. He's never been on felony probation before. He's got some misdemeanors. But he's asking the court to allow him to get some help. He's 39 years old.
All right. Mr. Solis, the court's problem is that you have not done anything. All right, this is what the court is going to do. Court is finding violation of condition number 2 true. The court is going to grant the motion, find you guilty. Revoke. Does anybody wish to speak to the time?
Nothing from the state, Your Honor.
All right, defense, do you want to speak to the time? The range of punishment is anywhere from 2 to 10 years in the prison.
That's correct, Judge. So in light of the fact that Mr. Solis is not going to be, given an opportunity to continue in his probation, I would ask that the court give him the minimum sentence.
All right. Court is finding violation of condition number 2 true. The court will find you guilty, grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Ana Solis and Gloria Torres. There's an affirmative finding of family violence. If you would like the therapeutic community, I can request that, but you'll need to request it as well. So if there's a drug or alcohol problem, they will address those issues with you. Would you like that?
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. This was not a plea bargain agreement. You do have a right to appeal. That right to appeal is limited though to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes.
All right, good luck to you.
Thank you.
Oh, and I'm sorry, one other thing, because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Thank you.
All right, good luck to you, sir. All right, court is calling 2020 CR 2127, State of Texas versus Gabriel Maurice Gobert. No. All right, on this case, the state was to tender an offer today. So has that been done?
Yes, ma'am.
All right, how much time does your client need to consider the offer?
I mean, just a couple of weeks, Judge. I'd like to be able to talk to him at length about the offer.
Sure. Ms. Ferguson, on this case, can I have a 2-week reset for a plea deadline date, please?
Yes, I can do the 13th.
All right, we'll come back on November 13th. Once you sign the reset form, you're excused.
Thank you.
You're welcome.